This program was made possible by the law firm of Zalman and Schnorman, whose practice is limited to personal injury and insurance law. Welcome to Lawline with your host, Alan Schnorman. Mr. Schnorman is a distinguished trial attorney, author, and lecturer. Each week, Lawline will bring you the most knowledgeable experts in the field of law today. And now, we introduce our guests and our host, Alan Schnorman.
Welcome to Lawline. Governor Pataki has proposed major sentencing changes that many believe will have a major impact on the effective functioning of the court and prison system. Critics of the new proposals call it an election year public relations gambit. Today we'll look at this issue with our guest, the Honorable Burton Roberts, Chief Administrative Judge, Bronx County. We also have with us Paul Schechtman. Paul is the New York State Director of Criminal Justice. Hello, Judge Roberts.
How are you, Alan?
Hello, Paul. Paul, give me an idea. What, basically, if you summarize what you're proposing, the new mandatory minimum guidelines, what are we talking about?
Here's what we're talking about. Let me start with last year, because that's the easiest way to understand this, and I'll be quick. Last year, we abolished early parole for repeat violent offenders. So they now get determinate sentences. Instead of a sentence like 5 to 15, they get a number like 7 or 10 or 12.
That's if you violate parole.
That's if you are convicted in our courtroom. If you are convicted, the judge will now pick one number and not a range. It is also a higher number, so we've increased sentences for violent felons, for repeat violent felons. What we propose to do this year, and what Bert disagrees with, is we have proposed to extend that to first-time violent felons. So they too would not be eligible for early parole, so they would get determinate sentences, and so that the sentences would be higher.
Are you saying that the judge will have no discretion whatsoever under your proposals?
I'm saying just the opposite. What I'm saying is the parole board will be eliminated. So instead of there being an additional level of discretion by the parole board, there'll be one decision by the sentencing judge, but the ranges will be higher, so the judge will not have the discretion to sentence to low ranges for violent felons.
Judge Roberts?
This is an attempt to take the discretion away from the judges on the lower range of sentencing. They have doubled, and indeed in some instances tripled, the minimum sentences for first-time violent felony offenses. Violent felony offenses, of course, are a broad term and indicates crimes for which no one may even be hurt, such as burglary too, such as other particular crimes which no one is actually injured. It's called a violent felony offense. Now, what's happened here is that by doubling and tripling the minimum sentence for a B violent felony, first-time violent felony offender, the minimum that a court can give now is 6 years. You can give up to 15. Can't give anything less. For a C, the minimum is now 4 years. Can't give anything less. Can go up to, as he can today, go up to 15 years. For a D, and there's some dispute as to the draftsmanship in the bill, but set that aside, I'm sure he has indicated, I want the record to indicate, that he has indicated that there are alternatives to D's and E's, but if the person is sent to state's prison, no longer can he receive a sentence of 1 to 3, 1 to 3 to 4, he has to get a minimum of 2.5, can get as much as 7, and for an E, he has to get a minimum of 2 up to 4. Now hear me just for one moment. That man or woman must do 6/7 of the time. It's no longer credit for good time in jail. What's going to happen here is...
So if you get 7 years, you serve
6. Now what happens...
What do you serve now?
Now he would get, before the sentencing, so-called sentencing reforms went into effect, the minimum sentence for a B would be 2 years to 6 years. You get 1/3 off, quite a big difference. Now what has happened here is there's no longer a management tool in prisons. These individuals who are bad guys, or they wouldn't have been convicted in the first instance, now have no incentive to behave while they're in prisons. 2, hear this for one moment. What's going to happen is we have to dispose of 85%, actually it's 84.8% of our cases by pleas throughout this state. We've only tried 5.7% to verdict. As a result, pleas are going to diminish. and we're going to have to try more. We don't have the wherewithal to try more than 5.7, 6% of the cases. And what is going to happen is detention facilities will not be able to hold these individuals. You can't hold them for more than a certain length of time. In any event, they're going to have to go out on the street. And do you know what robbers do when they're out on the street? They rob. Do you know what rapists do? They rape. So this bill, which purports to be a bill to increase public safety, is going to endanger public safety. It's going to eliminate parole, which provides the transitional supervision which is necessary to keep a person who comes out of jail on the straight and narrow, and it's going to cost, by the year 2005, $3.5 billion to create 13,000 new beds, and we could use that money to build crumbling schools, to improve our highways. Instead, we're going to engage in a WPA project for unemployed Republicans in Saranac Lake to build prisons. Now, I don't think this is a public relations gambit. Unfortunately, I think this is a bill in which certain people feel that they get some political advantage by catering to people's frustration and fear. But I am trying to tell them.
Well, how do you respond to that?
Easy. It is not a public relations gambit. It is based on the fundamental principle that Bert articulated, which is robbers tend to rob and rapists tend to rape, and the best way to deal with that problem is to impose significant sentences on them. But
why
one
not give
argument,
them 40 years? 50 years is the minimum then.
Bert, you take a reform that says if you rape, you must serve at least 5 years in jail. I don't think that's a radical proposal. But let's take some of the criticism.
Do you think any rapist would get less than 5 years now with the sentence? Do you think judges...
Well, then what are you upset about?
I am upset because...
Bert,
One moment. I am upset because you try to create an inflexible sentencing provision which deprives the court of meting out individualized justice. There is no way you can program into a bill all the different nuances that go into the commission, of a particular category of crime, or create a bill which takes into account the individualized differences of people who appear before the court.
Bert, let me put a question to you then. Is it your view that all sentencing ranges should start at 0 and go to 25? Should rape start at 0?
You want me to say something to you? I think in the best of all possible worlds, there should not be any mandatory sentences. Yes, I believe the court should have the authority within a certain range to be able to impose, Do I think 0? I think that a good judge, I think that a case that comes before me, yes. Okay. After 47 years experience in the criminal justice system, I think I am better able to determine what that sentence should be for that youth than some legislator who represents more trees than people in Warren County, or some prosecutor who's been in the court for some 6 months. Yes, I feel that I should have that discretion, not the young prosecutor and not the assemblyman or senator from Warren or Wyoming County.
Okay. I think this is easy then, because I think we're talking to a judge, and a very experienced and a very good one, who thinks that he should have from 0 to 40 range, and that
not 0 to 40.
To take 25, and that he knows the facts of the case best. The current law says he has from 3 to 25. Our proposal says raise that so that he'd actually have to serve 5 years. But I don't think there are very many people in this state who think that the sentence for rape should be 0 if a judge chooses for it to be 0.
Neither does any judge.
No
judge I know of would give 0 as a sentence for rape.
Now, let's back up and talk about some of the other issues. One of Bert's points is that this is going to wreak havoc in the prisons because good time isn't going to be available. Good time will be available. That's what that 1/7 off is. Appreciate that there are 10,000 people in your prison now who are ineligible for good time because they're serving life sentences. Appreciate that there are all sorts of other ways to have prison discipline. No serious prison administrator believes that these reforms will affect life in prison. The federal system does it this way. You're talking to a good judicial administrator, but if you talk to prison administrators, they will tell you that if you move our system to look like the federal system, you should not expect chaos in any prison.
One moment. I have spoken to good prison administrators, and one of the biggest opponents of this bill was one of a very fine New York City Corrections Commissioner, Catherine Abuddy, who's now a state senator. And I state to you that there is no way you're going to enable these individuals to behave themselves when they have to do 85.7% of the time.
Why does it work?
Let me finish.
Let me finish. No, you haven't let me finish the sentence. It's my turn. Why does it work in the federal system?
Well, it works in the federal system because, for the most part, in the federal system, you have individuals that commit crimes which really don't endanger public safety. You have narcotic cases. You have cases involving. Let me finish. The cases involving perjury of an FHA loan application, tax evasion, stock frauds. We're dealing with people that stick a gun in someone's ear for a wristwatch and the price of a beer. We're talking about crimes of violence. And if we don't get pleas from the lower range of those cases, if we have to devote ourselves to trying... Now, you got to let me finish, Paul, please. If we devote ourselves to trying the garbage cases which could plead out, and we won't have time to try those rape cases, which have take a longer period of time to try. We can only try a certain number of cases. And if we don't get those pleas, by God, we will not be able to try those cases.
Well, can you address that issue the judge is making? Is saying that under your guidelines, if they were instituted by the legislature, that there'd be no incentive for the defendants to take pleas, and that the court system as now constituted couldn't possibly try the number of cases that would be required.
Right. Bert's wrong. Pleas happen in one of two ways. If the prosecutor says you must plead to the charge, right? So you're charged with a rape, a B felony. Under our proposal, the judge's sentence must be between 6 years and 25. And everyone knows that the way pleas happen in our courtroom is a judge says if you go to trial, the sentence will be longer. And that's precisely what will happen. The judges will go to the higher ends of the range for the trial cases and to the lower end for the plea cases. Alternatively, pleas happen in our courtrooms because prosecutors say, I'll reduce that rape to an attempted rape, and therefore you have incentive to plead. Nothing in the bill prevents that charge reduction. This is not a mandatory, discretionless system.
So it's your position that this will not affect pleas, the number of pleas? It will not affect pleas. Remember the following. When the last significant sentencing reform we had was the federal sentencing reform. And everyone cried out in precisely the way Bert's crying out, the sky is going to fall in and we will have more trials. We have had less trials. Right? There is no empirical data to support Bert's proposition that we will have more trials. Judge Roberts?
75% of the federal judges, at least 75% of the judges, consider the sentencing guidelines imposed in federal court to be an absolute disaster.
As do I. And that is why we did not adopt them in New York.
Ma'am won't let me finish. And as a result, a great deal of injustice is done, a great deal of unfairness occurs. Why? Because you can't pigeonhole sentences.
And that's why we have broad discretion for judges.
You don't have broad
6 to 25. That sounds like broad discretion.
If you want to have broad discretion, why not make it 0 to 25? Why say to a court, to the neutral magistrate, that he is bound not to go below 6, no matter what the particular robbery was? Two Bowery bums.
Way of saying that rape is a serious crime, and if a judge thinks the number is 0 for that, a judge is wrong.
I may think that two Bowery bums on the street who've been friends for 20 years, and one guy picks up a stick and says, give me that bottle of wine. He commits the crime of robbery 1. Now, I don't think I should have to give that person 6 years, particularly if you have a district attorney that feels his plea policy is that if a person is indicted, you don't go beneath that particular charge. Let me finish. Assume that you also have another guy that goes into a bank with a submachine gun, shoots up the bank. Now, I don't need to have a range. I know I'm going to give that fellow who has a criminal record somewhere between 15 and 25. He's a bad guy. But the person with the stick, or let's say you have a student that's an honest student in high school. Let's say he and another guy go out on the street. Let's say they don't know what they're doing. Let's say they grab a kid and they take his lumberjack. Not a nice crime. Not a nice crime. Both working together take this kid's lumberjack. Under the law, the inflexible law, we have to give that kid a minimum of 4 years. Kid may be an honest student in high school. The kid may have the kid may have the ability.
It's easier to argue against sentencing schemes that aren't being proposed.
That for scheme is being proposed. That's a robbery too, and he can't get less than 4 years.
The proposal says that if you are 15, 16,
I didn't say
17,
15,
or
16.
He's a high school kid. 16, 17,
Paul,
18, the judge has discretion to impose
If I may,
probation.
Listen to me.
Paul, 1 second, Judge, please. Paul, if you just answer me this. What you're doing is you're taking the discretion away from the court, from the judge.
You're giving the discretion to Warren County, Wyoming County, Lake Saranac.
I want to
Do
just
you
say
have-
something about
do you
Warren
have-
County, Wyoming County. They ain't bad places, and they're
No,
also safer than
the
New
only
York
thing
City.
I want to
If you have 3 people living in a county, they're pretty safe.
Is it that you have a lack of confidence in the judiciary to do the right thing?
Let me make one thing clear. The people we're taking discretion away principally from is the parole board.
Well,
When
you
Bert-
just tripled sentences.
Watch. When Bert used to sentence that rapist to 5 to 15,
It wasn't a predicate felon to 7.5.
Quickly, we have to go to a break.
to 5 to 15, he didn't know whether the person got out in
7.5
5,
to 15.
7, 10, first time. He didn't know whether he got out 5, 7, 10, or 15.
Want to know something?
Now-
I know when a person gets
now
out.
Bert-
Because when I
now
sentence-
Bert picks
Now,
one
listen to
number
me.
and there
We
is
have
no
to go to a
parole.
break.
I know
Now
when he
you're
gets
watching
out.
Law Line.
I
Stay
know,
with us.
I know when he gets out. I know when he gets out because when I sentence a person to 7.5 to 15, I make a recommendation when I sentence that individual to the parole board. And I make certain when I get a letter from the parole board, I indicate whether I wish him paroled or don't wish him paroled.
And they are
There
totally
some-
free to ignore it.
We'll continue this right after the break. You're
Well, I
watching
haven't
Law Line.
ignored my
Stay with us.
recommendations, I'll tell you that now.
Hello, I'm Alan Schnorman. Most of you know me as the host of Law Line, where I interview the most knowledgeable attorneys in the field of law today. So I understand the importance of choosing the right attorney to represent you. With so many law firms to choose from in personal injury law, how do you know who to call? At my firm, Zalman & Schnorman, we fight for the rights of accident victims. If you have been hurt in an accident of any kind, including construction accidents, you may be entitled to a substantial money award for your pain and suffering. Don't try to evaluate your case yourself. Call us at 1-800-LAW-LINE for a free consultation. If you are too injured to come to our office, we will come to you. We get paid only when your case is settled or won. If you have any questions about your accident, call us at 1-800-LAW-LINE. Remember, the insurance companies have lawyers representing them, and so should you. Hello, you're watching Lawline. We're discussing the new proposals for sentencing guidelines here in the state of New York. It's the impact on the court system. Our guests are the Honorable Burton Roberts, Chief Administrative Judge of Bronx County, and Paul Scheckman, New York State Criminal Justice Director. Paul,
Wait a minute, I wanted to answer that
one
thing.
second, please, Your Honor. If it has been come out now that Bar Association's presidents of over 60,000 members are against your very proposals, how do you respond to that?
I think they're wrong. I think most Bar Association members and presidents tend in our state, and I say this respectfully, to represent defense associations and defendants.
Let me answer that.
I think if you ask the public what its view are on whether these sentences are appropriate, whether a first-time rapist should do at least 5 years, they will say yes.
To answer that, the bar associations that have approved by resolution opposing this bill, it's the New York State Bar Association, 60,000 members. The board of directors and executive committee voted unanimously in favor of opposing this bill. They knew it would result in a diminution of 50% of judicial resources to try civil cases. The New York State Trial Lawyers Association, not renowned for its liberalism, the Nassau County Bar Association and Suffolk County Bar Association, made up of an abundance of Republicans, all opposed this particular bit of legislation. Now that's not knee-jerk liberals that we're talking
You have
about.
placed this. You have placed the proposals in the budgetary
For what it's
bill.
worth, every DA in the state supports this.
Okay.
That's not a surprise. Is that a surprise? They won't support any. They won't oppose anything that looks like it's going to diminish their discretion
Well,
and their power.
You have placed this in the budget bill.
Right.
Many people have said you've done that because of its political tie into the budget,
No.
as opposed to a separate bill itself.
No, here's why we've done it. It's simple. This is really one of two pieces. The increasing the sentence piece is one of two. The other reduces sentences for nonviolent offenders. It creates a maritime system.
In addition,
that piece would result in 1,000-bed reduction. 1,000 people would come out of prison early. That is a savings to the state of $10 million. So this is two-part. It saves $10 million, and when you save numbers like $10 million, you've got to do it in the budget.
Isn't it true that your proposals also cut spending for the drug rehabilitation programs as well as other social programs?
The proposal reduces some spending in the social area and increases it in others. It adds $13.8 million for grants for violent juveniles.
How do you respond to the former commissioner, Catherine Abante's position that your estimates are way off?
I respond to it the following way. Catherine and I debated this last week, and what she said at the end was that her numbers were way off. They're exaggerated because she fails to take into account the fact that under our current system, I got to finish, Bert, under our current system, people don't get out at the minimum. Her numbers are inflated by a factor of 2. Let's be clear. These proposals will increase the number of violent offenders in our prisons. They will do it somewhere between 5,000 and 9,000. But 13,000 to 20,000 with its Catherine's kinds of numbers are simply not realistic, and she's admitted as much.
Judge?
He has now in receipt of a letter dated May 2nd, 1996, which indicates that she in no way takes back one thing, and I have the letter in my possession today, a copy of that letter.
I don't. I've never seen it.
Well, I'm going to show it to you. I want you to read the letter and then tell me that she did not, that she went along or disputed what you said. And I have the letter right here, sir. Here is the letter. And I now read from the letter.
Just read in part, Judge. We really don't
I
have
will. I am writing to object in the strongest terms to your statement that Senator Abadi agrees with me that she's done the math wrong. On my report, Dollars and Cells, which you made before the Association of the Bar of the City of New York, she goes on to state that her report is a report that they should do the same data and the same research. She also goes on to say, Mr. Schechtman, she goes on to say, Commissioner, that you, in your graphs that you propose or you put up, goes to 1999. 65% of the increase in cost for this bill will occur. Now you let me finish, sir.
All right, Bert, it's a half-hour program. I get 2 minutes.
You will let me finish, sir. That 65% of the cost for this particular so-called sentencing reform, which is going to endanger public safety, will occur between 1999 and 2005. 65%. And his letter, which he wrote, does not take into account the baby boom bubble, which is going to occur around 2000.
Here we go. My letter that I wrote to Assemblyman Feldman projects to the year 2005. It is the single most sophisticated projection that the state of New York has ever done. It calculates the increase here as between 5,500 and 9,000. Those are not trivial numbers.
Talk to me in practical sense. Judge, what would happen in 5 years? Let's assume this year the legislature approves the bill, the governor signs it. Tell me what's going to be in 5 years.
What's going to happen is the prisons are going to become overcrowded. What's going to happen here is crime is going to increase because we're not going to be able to try these people within a reasonable period of time. Robbers and rapists will be on the street because there were no pleas to the garbage cases. And as a result of this inflexible policy, we're endangering public safety. We have an adverse impact on our court. We are going to cost the city some $3.5 billion by the year 2005. Schools are going to continue to crumble. And what we're going to have is an imagined political advantage to people that are going to run 3 years from now or 2 years from now. I say that's not the way to run government. This isn't a public relations gimmick. This is something to be done for an imagined political advantage. I say to you, the public, you cannot all be fooled. And if the public realizes that this is going to endanger public safety, they're going to realize what this is. And I state to you now, talking tough doesn't decrease crime. Acting smart decreases crime. Because when you act smart, you are tough. And you put those people in jail swiftly and certainly. Now, the thing that deters crime is speed and certainty of adjudication, not the severity of sentence. I've learned that in 47 years in this system. Severity does not decrease crime. The swiftness and certainty of adjudication, getting them in within 3 months, that's what decreases crime.
Well, how do you respond to that?
I respond in the following way. The sky will not fall in. If we sit here 5 years from now or 10 years from now, I promise you that the plea bargaining rates in this state will be exactly the same. What there will be is between 5,000 and 9,000 more violent criminals in jail at the same time that we try to reduce the number of non-violent criminals in jail.
Paul Sheckman sent out a report, Disparity in Sentencing, in September of 1995. He called this an informed, sophisticated report in the accompanying letter. It indicates that minorities, with regard to the processing of cases, being discriminated against with respect to indictment.
Look, this isn't right, because none of those statistics are true.
You said it was a sophisticated report.
Bert,
You're the one that introduced that report.
There are people who listen to this and actually think that it matters. The report shows that there's no discrimination in the prosecutor's decision. That's a terribly important
why don't we investigate that report? Why don't we investigate that report before we lengthen sentences? Why don't we make sure before we put the poor and the blacks and the Hispanics in jail for a longer period of time? You may laugh. You introduced that report. And it came out of the Department of Criminal Justice Services. You called it an informed report.
I introduced that, and on a
why did you distribute it to 100 people and not to the press? Tell me why.
I introduced that report, and on a cable show that goes out to lots of sophisticated people, you've grossly misstated what it says. Now, that's wrong. What the report says is there is no discrimination, no disparity in the prosecutor charging decision. That's one. It says, two, there is no disparity on the basis of race in the decision of judges to send people to state prison. So on that score, Bert and his colleagues prove well. It says there is evidence of racial disparity at the very low end in people who are getting local jail sentences of less than a year. This bill has nothing to do with that. So it is terribly important that when we debate this bill, and it's a significant debate, that we debate what the bill is about.
Don't you think don't you think that report should come into consideration? Don't you think if the Department of Criminal Justice Services indicates that there is discrimination against segments of a population when we have a divisive society now, don't you think that before we lengthen sentences, don't you think that we should at least explore that?
What would you like to say in a half a minute?
I'd say the following.
In a half a minute.
In a half minute. Debate this on its merits. Debate this as whether we should be increasing sentences for violent offenders. Don't debate this in terms of the Bowery bum who's never been indicted in the Bronx or anywhere else. Don't debate this in terms of racial disparities that don't exist in the indictment decision or the prosecutorial decision. And don't misstate the facts. You can have a reasonable debate on the facts. Reasonable people can differ, but
response in a half a minute.
Stop talking tough. Start acting smart. The unfairness and injustice will occur with this bill. We're going to have less plea bargaining. We're going to have less pleas. As a result, we're going to have more robbers and rapists on the street awaiting trial. Speed and certainty of adjudication.
Paul
fairness
Sheckman,
toward the defendant. That's
New
what
York
we
State
need.
Commissioner on Criminal Justice, thank you for appearing on Law Line. And the Honorable Burton Roberts, thank you once more for coming down.
Thank you.
To Law Line. And as always, I wish we had more time. Thank you for watching Law Line. This is Alan Schnorman.
You have been watching Lawline with your host, New York trial attorney Alan Schnorman. Mr. Schnorman will be back with you next week at the same time. If you have any questions about this week's program, please write to Lawline, 63 Wall Street, New York, New York, 10005, or call area code 212-432-9111. This program was made possible by the law firm of Zalman and Schnorman, whose practice is limited to personal injury and insurance law.